After having understood what is tort, what are the essentials of tort, maxims such as ubi jus ibi remedium, and other such things, injuria sine damno, damnum sine injuria, we go on to understand general defenses. Now, why general defenses after introduction? So that whenever we study any specific tort after this, we will understand whether there are any general defenses available to this or some other defenses. Now, what do you understand by general defenses? Defenses, as the word suggests, says that you can defend yourself for a wrong that you might have done if it falls under the category of a defense. There are two kinds of defenses. They can be general defenses or specific defenses. General defenses are available to all kinds of torts. So, for example, it may be available to torts which require malice also, may not require malice. But for specific defenses, you need to meet specific requirements of the tort itself. Now, in case a plaintiff brings an action for tort, the defendant can avoid liability in case he proves certain defenses. So, for example, somebody brings a tort action for tort against X. X being the defendant, he can prove that he did that tort under a category of a defense. So in that case, you might either absorb liability, or in certain cases, the liability may be decreased because you take recourse to a certain defense. Now, the general defenses are voluntary non-fit injuria. That is, the plaintiff himself took the injury, or the defense of consent, as we call it. The next being that the plaintiff himself or herself is the wrongdoer. The plaintiff is the one who did the wrong. If the defendant proves this, he will take a defense. Inevitable accident. It was an accident of such a nature that could not have been avoided. This is what an inevitable accident means. Then the next is an act of God. We will discuss in detail what an act of God is. It is generally natural calamities which are not in human control. So an act of God. Private defense. If the defendant did a tort in a defense to an act being done to him, then he can take this. A mistake. A mistake may be a little tricky because mistake generally of law or of fact is not considered to be a defense, but we will understand in detail what does it mean. Necessity. That action is absolutely necessary to be done in the situation to prevent a greater harm. In that case, you can take a defense. Statutory authority. You were authorized by the statute to do something, and that resulted in a tort which may then absolve you of liability. Always remember, defenses are taken by the defendant because the plaintiff is the one who alleges that so and so person has done a wrong, so I want this person to be prosecuted or to pay me damages for a tort, and then I take a defense. That's the defendant takes a defense that no, I did so and so tort as a result of so and so act. Now, the first is voluntary non-fit injuria. It means when a person consents to the infliction of harm upon himself, he has no remedy for that in a tort. Okay, so he himself agreed to the infliction of wrong, and hence he would have no remedy. No person can enforce a right which he voluntarily waived or abandoned. You yourself agreed to the commission of the harm that happened to you. Then once the harm happens, you cannot go back and say, see, this is the tort that happened to me, now pay compensation to me. Now, this consent, the essential part here is a voluntary non-fit injuria is that you should consent to it. This consent may be expressed, okay, I agree to take this harm on me, or maybe implied by the conduct. Express can also be in the form of signatures taken or any other form, and implied in terms of the conduct of the person. Now, many a times, the consent may be implied or inferred from the conduct of the parties. Now, the conduct of the parties may result in an implied consent. For example, a player in the game of cricket or football is deemed to be agreeing to any hurt which is likely to which may be likely in the normal course of the game. So, for example, somebody hits a boundary and a ball comes on me. I have agreed to sit in that position. Or consent which is expressed can be, I do a bungee jump. I sign consent documents and I agree when I'm jumping, I agree to the acts. Correct? And I also sign waivers when I do bungee jumping or any such sport activities. However, in a game of cricket or football, you agree that any such act which might hurt you during the course of the actions can be taken up. Now, for the defense of consent to be available, the act causing the harm must not go beyond the limit of what has been consented. When I sit in a game of cricket, I consent that any act which is happening as a result of the game can be, I will not, the parties will not be liable for it because I consented to it. For example, if a ball hits me, it is voluntary not fit injury. But what happens if the roof falls on me? That is not something I consented to. I absolutely did not consent that I'm sitting in a stadium and the roof falls on me. That is not covered under the category of voluntary non-fit injuria. Example, if a surgeon negligently performs an operation, he cannot avoid liability by pleading the defense of consent. Okay, if it is something related to the operation, and if it's a very risky operation, then if you prove that you have taken due care and skill and reasonable care and diligence, then you will be absorbed of liability as a surgeon. However, if you negligently perform the operation, right now we see cases of operations being performed under flashlights of cameras. That is not a consent. Nobody consented that they will get operated under a flashlight. Correct? Now, Hall versus Brooklyn's Auto Racing Club is an example of voluntary not fit injuria. What happened in this case was the plaintiff was a spectator at a motor car race being held at Brooklyns on the racing track owned by the defendant. This is basically, if for example you've seen Formula 1 races, right? So something like that, racing car. During the race, there was a collision between two cars, one of which was thrown among the spectators, thereby injuring the plaintiff. This is very common. Sometimes while turning cars, also cars flip and enter into the arena. It was held that the plaintiff impliedly took the risk of such injury, the danger being inherent in the sport, which any spectator could foresee. The defendant was not held liable. However, in the same case, the example I gave earlier, had the roof fallen where the spectators were sitting, or something else of a similar nature happened, then you cannot claim the defense of voluntary non-fit injuria. Why? Because first, the consent must be free, and second, the act must be such as has been done, consented for. Now, what is consent must be free? For the defense to be available, it is necessary to show that the plaintiff consent to the act done by the defendant was free. You freely consented to the wrong. That is, you freely consented to it. There was no misrepresentation of fraud or hiding of facts that was done to take your consent. If the consent of the plaintiff has been obtained by fraud or under compulsion or under mistaken impression, such consent is not a good defense. For example, when you do horse riding, you impliedly consent that to any injury which might happen as a result of the horse either becoming unruly if the horse is of good health and of good temperament. Now, what happens? The horse rider knows that this horse is a little unstable in the mind, or is not stable, not capable, or not fit to do horse riding. And yet he tells you, no, nothing will happen. There is nothing wrong in it. And you sit on it. And then if it causes you injury, then you have not consented on the same facts. You've consented on different facts. You believe that the horse was of good temperament and correct mind, would not have resulted in an injury. Okay. Now, another thing, if a guest is requested to sit in the drawing room and without any authority or justification enters the bedroom, he would be liable for trespass, and he cannot take the defense of your consent to his visit to your house. For example, somebody enters your bedroom and then gets injured because of some trap you might have kept to protect your house. The person cannot take defense. You cannot sue you for tort, and you can take the defense. So the person cannot say that he had come on your authority. You did not allow that person to enter your bedroom. You only allowed that person to be in your guest room. Consent obtained by fraud is not real and does not serve as a good defense. You tell somebody to ride a motorbike. He agrees to the normal accidental damages which may happen to him if he does not drive correctly. But if you know that the bike's brakes were failed and you did not tell the person, then you cannot take a defense of voluntary not fit injuria. Now, the maximum voluntary not fit injuria to apply, 2 points have to be proved. There are two essential elements which need to be proved. The person knew that the risk is there, and knowing the same, he agreed to suffer the harm. Mere knowledge of the risk does not result in a maxim or application of the defense of voluntary non-fit injuria. Merely because the plaintiff knows the harm does not imply he assents to suffer it. An example of this is the case of Smith versus Baker. An excellent example to understand voluntary non-fit injuria. It says the plaintiff was a workman employed by the defendant on working a drill for the purpose of cutting rocks. Now he was at a place where there were huge rocks and he was working to cut those rocks. Now, by the help of cranes, stones were being conveyed from one side to other. Now, stones which had to be cut were being transferred from one side to other. And each time when the stones were convened, the crane passed from the plaintiff's head. While he was busy in his work, a stone fell from the crane and injured him. Now, the employers were negligent in not warning him at the moment of recurring danger, although the plaintiff had been generally aware of the risk. Now, there was general awareness that this is happening and it might result in injury. But somebody going to work to cut stones does not agree that if a stone falls on him, he agrees to that damage. Correct? Now, it was held by the House of Lords that as there was mere knowledge of the risk, without assumption of it, the maxim voluntary not fit injuria did not apply and the defendants were held liable. Correct? Similar is the case when there are constructions of big bridges happening. They know there is a risk that the bridge might fall or something like this might happen, but you do not consent to it. At times, there are people crossing bridges. They have a risk, but they do not consent to it. Mere knowledge of a risk is not consenting. You must consent to the risk. Now, in Baker versus Smith, what was held? It was held where a person undertakes to do work which is intrinsically dangerous, notwithstanding that reasonable care has been taken to render it as little dangerous as possible, he no doubt voluntarily subjects himself to the risk inevitably accompanying it, and cannot, if he suffers, be permitted to complain that a wrong has been done to him, even though the cause from which he suffered might give to others a right of action. But where? Now here comes the catch. The first part says that when you agree to undertake an intrinsically dangerous work, and notwithstanding that you have taken reasonable care to ensure that the work is rendered as little dangerous as possible, you voluntarily subject yourself to the risk. However, a risk to the employed which may or may not result in injury has been created or enhanced by the negligence of employer. Here the essence is that it has been created or enhanced by the negligence of the employer. The risk is enhanced. In the case of Baker versus Smith, yes, there was risk, but you carrying the things by crane or overhead enhanced the risk by the negligence of the employer. Does the mere continuance in service with knowledge of the risk preclude the employed, if he suffers from such negligence, from recovering in respect of his employer's breach of duty? I cannot assent to the proposition that voluntary non-fit injuria applies to such case and the employer. So, this means that yes, there was a risk, but does it include within it the enhanced risk created by the negligence of the employer? No. If this is such a case, then what will happen? This will result in the employer being liable. He cannot take the defense of voluntary not fit injuria. Now, for the defense to be available, it is necessary the act done must be the same to which the consent has been given. If the act which causes the injury is separate from the one to which consent is given, no defense will be available. We go back to the example of a cricket field. I consented to the act of being hit by the ball inevitably because that is incidental to the game. I did not consent to either stampede. I did not consent to the falling of the roof. When I was working as a stone cutter, I consented to the damage associated with the stone cutting. If the stone threw on me while cutting, or if something like that happened, I did not consent to the stone falling on me. So voluntary non-fit injuria is not applicable. Now, what are the limitations to the doctrine? This doctrine is one which has limitation on it. The first being rescue cases, where somebody rescues the other person. Now, rescue cases form an exception to the application of the doctrine of voluntary non-fit injuria, where the plaintiff voluntarily encounters a risk to rescue somebody from an imminent danger created by the wrongful act of the defendant, he cannot be met with the defense of voluntary non-fit injuria. I am doing something wrong and somebody prevents that wrong. I cannot say that person voluntarily took that decision. Rescue cases. For example, in Haynes versus Hardwood, the defendant's servant left 2 horse vans unattended in a street. Okay, now whenever you leave horse vans or you leave animals or you accompany animals, you have to keep them attended because it might result in some wrong. A boy threw stones on the horse and they bolted. That is, they started acting in a rage. They started running here and there, causing grave danger to a woman and children on the road. Now, there were women and children standing on the road, and when the boy threw stones at the horse, they obviously got agitated and they started running here and there. And as a result, it might have caused injury to the women and children. Now, what happened? A police constable who was on duty inside a nearby police station, on seeing the same, managed to stop the horse, but in doing so, he himself suffered serious injury. Now, he tried to stop the horse, that is, he tried to rescue the women and children. It being a rescue case, the defense of voluntary non-fit injuria was not acceptable, and the defendants were held liable for negligence. Why? You are required, you are mandated to take care of your horse. You did not do it. Now somebody took care of it. You cannot say that person voluntarily consented to it. So rescue cases are 1. Death to rescue another from imminent danger of personal injury or death, whether the person is one to whom he owes a duty of protection as a member of the family, or is merely stranger to whom he owes no special duty. If somebody has died, this is an extension of rescue basically, that death as a result of rescue is also no exception. However, a person who is injured in an attempt to stop a horse which creates no danger will be without remedy. So there has to be a rescue case. There has to be an imminent danger to somebody else. Merely a horse running on the street, and if you try to stop him and then you get injured, you cannot go to the owner of the horse and say, see, I tried to stop your horse. If that horse is trying to run into somebody, injure somebody, in that case, if you're trying to rescue somebody of an harm, then you can claim the defense. Now, the next is the plaintiff himself is the wrongdoer. Then he cannot say that I want remedy out of the defendant. When the plaintiff himself is the wrongdoer, he cannot claim a remedy from the defendant. This is defined by the Latin maxim, ex turpi causa non obiter actio. That is, an immoral cause, no action arises. For an immoral cause, no action arises. It means that if the basis of an action of the plaintiff is an unlawful contract, he will not, in general, succeed to this action. In general, right? Not every case of plaintiff is a wrongdoer will result in absolving the defendant of the liability. So Frederick Belloc, when the plaintiff himself is a wrongdoer, he is not disabled from recovering in tort. Now, he's not disabled unless some lawful act or conduct on his own part is connected with the harm suffered by him as a part of the same transaction. So, he is not completely disabled from recovering a tort unless his own unlawful conduct has resulted in the harm which was the part of the same transaction in which the defendant was also there. Merely because the plaintiff is a wrongdoer is no bar to an action for damage. He may claim compensation if his wrongful act is independent of the harm caused to him. There might be an act. The act is independent of the harm caused to him. Then he may get it. He may lose his action if his wrongful act is the real cause of his harm. His own act is the real cause of the harm, then he will not get a defense here. There could be another situation also, and that is that of contributory negligence. What is contributory negligence? Both the plaintiff and the defendant were contributors in the negligent act which happened. In such a case, the plaintiff is not entitled from claiming compensation, but the compensation payable to him is reduced in proportion to his own fault in the matter. So compensation payable to him will be reduced. Next is an inevitable accident. Now, what is an accident? An accident means an unexpected injury, and if the same could not have been foreseen or avoided in spite of reasonable care on the part of the defendant, it is an inevitable accident. So accident is something which is unexpected and injury, and if the same is not avoidable, or if even despite reasonable care and skill on the part of the parties, the same could not have been appointed, it is called an inevitable accident. According to Pollock, it does not mean absolutely inevitable. Absolutely inevitable, there's nothing absolutely inevitable, but it means not avoidable by such precautions as a reasonable man, by doing such an act then and there, could be expected to take. So you could have avoided it had it been something which you had time for. But in the current scenario, even despite precautions you could have taken, you could not have avoided it. It is therefore a good defense if the defendant can show that he can neither intended to injure the plaintiff nor could he have avoided the injury by taking reasonable care. One is you did not have the intention to injure the plaintiff. Second, you took reasonable care and precaution, yet you could not avoid the injury which happened. Now, the case here is Sridhar Tiwari versus UP State Road Transport Corporation. What happened is a bus A belonging to the corporation reached a nearby village and a cyclist suddenly came in front of the bus. Now, it rained, the road was also wet, and the bus driver applied brakes to save the cyclist. But the bus skidded on the road. Now, this resulted in the rear portion of the bus hitting another front portion of another bus which was coming from the opposite direction. What happened? There was a cyclist who suddenly came in. When the brakes were applied here, it hit the other bus. It was found at that time that both the buses were being driven at moderate speed, and thus the accident had occurred despite due care on the part of the drivers of both the buses. It was held the accident had occurred due to inevitable accident, and therefore the defendant corporation was not held liable. Now, in this case, had the buses been driving negligently or rashly, or had the bus driver had enough time to see that there was a cyclist and then similar situations happened, this could not have been an inevitable accident. Here they took all reasonable care and precautions, yet something wrong happened. This does not result in an liability. Padmavati versus Doganika. Two strangers took a lift in a jeep. Now, shortly thereafter, one of the bolts fixing the right front of the wheel of the jeep to the axle gave away and the wheel flew from the axle. Now, somebody took a lift, and what happened? The tire removed, and the tire was removed from the jeep. by some axle, the bolts being loose. The jeep was toppled and the two strangers got serious injuries and resulted in the death of one of them. It was found that it was a case of sheer accident, as there was no evidence to show that the defect was a patent one and could have been detected by a periodical checkup. Had it been something that was very obvious and could have been avoided, it would not have been an inevitable accident here, but something that was not expected or not something that could have been deducted by periodical checkup. The defendant, that is the driver of the jeep, and his master were not held liable, right? So accident should be such which cannot be avoided. Inevitable accident. The defense is not an accident. The defense is an inevitable accident. Now, the next is an act of God. What do you understand by an act of God? In Halsbury, an act of God. Now, what do you understand by an act of God? In Halsbury's Law of England, act of God is defined as an act of God in the legal sense may be defined as an extraordinary occurrence of circumstances which could not have been foreseen. So, first, it has to be an extraordinary occurrence of circumstances which could not have been seen and which could not have been guarded against, or more accurately, you cannot foresee it, you cannot guard against it, or more accurately, as an accident due to a natural cause, directly and exclusively. So it is a result of a direct natural cause, either and directly and exclusively, without human intervention. In an act of God, there is never a human intervention, and which could not have been avoided by any amount of foresight, pains, care, reasonably to be expected of a person thought to be made liable for it, or who seeks to excuse himself on the ground of it. Now, such extraordinary circumstances which could not have been foreseen or not have been prevented, could not have been prevented despite reasonable care from the person whom you want to make liable. The occurrence may not be unique, and nor it be one that happens for the first time. It is enough that it is extraordinary and such could not reasonably be anticipated, and it must not arise from the act of a man. So it is extraordinary, could not be reasonably anticipated, and should not have human intervention. Now, for example, earthquakes, act of God. Excessive rain, act of God. Cyclones, tornadoes, hurricanes, all are act of God. Two important essentials are needed for this defense. There must be working of natural forces. See, natural forces here is important because it is an act of God. And the occurrence must be extraordinary, not one which could be anticipated and reasonably guarded against. Nicholas versus Marshland is an excellent example of an act of God. This portrays that it not be something extraordinary, need not have happened first time, but should be something which is so need not be extraordinary in the sense, need not be something very unique, but extraordinary in the sense of gravity. There the defendants created some artificial lake on his land by damming some natural streams. Now you create a dam. Once there was an extraordinary rainfall, stated to be the heaviest in the memory of humankind, as a result of which the embankments of the lakes gave away. So all those protective measures which you had created were washed off. The rush of the water washed away 4 bridges belonging to the plaintiff. Now what happened? Because of this lake being broken, 4 bridges of the plaintiff were demolished. It was held that the defendants were not liable as the loss had occurred due to an act of the God. So this was a result of act of God. The rainfall was extraordinarily heavy and could not be anticipated if the rainfall is a normal one, which could have been expected in certain areas. The defense of act of God could not have been pleaded. Had the rainfall been something that is very normal and the similar circumstances happened, it could not have pleaded act of God. The next category of defense which we will discuss is the defense of private defense. Now this is also available under the criminal law, but here we will understand what is a private defense under the law of torts. It says that the law permits use of reasonable force. What is important to understand is that the force should be reasonable force to protect one person or property. So the right of private defense is available both against torts against the human body or torts against property. If the defendant uses the force which is necessary for self-defense, he will not be liable for the harm caused thereby. So in case you use a force which is reasonable enough to protect your own self, you can use a defense of private defense if a plaintiff alleges a tort against you. The use of force is justified only for the purposes of defense. Now, defense, what do you understand by defense then? That you will have to first have some danger on you, some danger inflicted on you. That means that first the person, the plaintiff must have done something against which you are defending yourself. There should be imminent threat to personal safety or property. For the right of private defense to be available, there has to be an imminent or immediate threat. It cannot be that the plaintiff has told you, I will beat you someday. And then one fine day you go without any provocation, without any damage, or without any imminent threat to you, and go and assault the plaintiff saying that I used my right of self-defense. Self-defense is available only and only when you are under imminent threat to your property. If somebody comes and tells you, I'm going to trespass your property someday, you cannot use private defense randomly without that person actually doing something wrong. So there has to be an immediate or imminent threat. It is also necessary that such force is absolutely necessary to repel the invasion should be used. Now, whatever force which is used should be absolutely necessary in that case. It should not be more than what is required. Absolute necessity. For the protection of property also, law permits taking of such measures as may be reasonable for the said purposes. Now, some people have electric wires. Some people use spring guns. That will be only possible if there is private defense and if there is imminent threat and danger. Anybody entering should not be hurt. Only if there is some wrong that happens, then only that should be used. Next category of defense is mistake. Now, mistake is of two kinds, whether of fact or of law. Now, understand, generally mistake is not considered to be a defense. So, mistake is generally no defense to an action for tort. Under the law of tort, or for that matter, under any law, a mistake of fact or a mistake of law cannot be treated to be a defense. When a person lawfully interferes with the right of another person, it is no defense to say that he had honest belief that there was some justification for the same, when in fact no such justification exists. That means you cannot claim defense of mistake. To this rule, there are some exceptions where the defendant may be allowed to avoid his liability by showing that he acted under honest but mistaken belief. Now, I'll give you an example of this. For example, there are two similar dogs and they are playing together, and the owner of one dog latches the other and brings him home, believing him to be his dog under an honest mistaken belief. Then you will not be liable for a tort. We'll understand what category of tort does this come under, but you will not be liable for this. So it has to be an honest mistaken belief, but mistake is very rarely considered to be a defense. The next category is necessity. Now, we will also differentiate necessity from private defense. An act causing damage, if done under necessity to prevent a greater evil, is not actionable even though the harm was intentionally caused. Now, you in this case of necessity do an act to prevent a greater evil, a greater damage. Okay, necessity should be distinguished from private defense. Why? In private defense, there is an imminent threat to you and then you act to protect. However, in case of necessity, there is a danger to some other thing and then you protect it. In necessity, there is an infliction on harm on an innocent person. Whereas in private defense, the harm is caused to the plaintiff who himself is the wrongdoer. See here this is another important point which should be highlighted, that under the defense of private defense, you will also see that the plaintiff will also be the wrongdoer. Then only you will inflict some wrong. If the plaintiff has done nothing, then you cannot inflict a wrong for private defense. Correct? In necessity, if something is happening, you inflict a thing to protect something. Necessity is also differentiated from inevitable accident, because in necessity, the harm is an intended one, whereas in inevitable accident, the harm is caused in spite of the best efforts to avoid it. If a person enters another land to prevent fire, he's not liable for trespass. Now, how do you differentiate inevitable accident and necessity? In inevitable accident, you had on purpose intended to inflict that harm to prevent something. In inevitable accident, you did not want to cause an harm. Correct? Now, for example, if there is a fire happening, and if you pick somebody up and push them, you cannot hold somebody liable for a tort of battery. Why? Because you did not want to hit them. That injury cause will not be as a result of what? Intention. It was to prevent greater damage. If you enter somebody's land to prevent fire, it will not be a trespass. Correct? Now, statutory authority. Statutory authority, what do you understand by statutory authority? By statutory authority, we understand that there is a authority of law which enables you to use that power to do something. And that can be taken as a defense. I was under the authority of law to do what I'm doing right now. The damage resulting from an act which the legislature authorizes or directs to be done is not actionable, even though it was otherwise a tort. So, in case there is a tort, it will not be actionable if the legislature authorizes such act. When the act is done under the authority of an act, by act here we mean law, it is complete defense and the injured party has no remedy except for claiming compensation as may have been provided by the statute. So somebody takes up somebody's land, enters somebody's land under statutory authority. You can only take a remedy of what is available under the statute if that act is done beyond what is stated in the statute. It is necessary that the act authorized by the legislature must be done carefully, and therefore an action does lie for doing what the legislature has authorized if it is done negligently. Now, for example, the legislature authorizes removal of unauthorized occupation. Correct? If you occupied a land unauthorized way, the legislature allows that you can remove this piece of occupation. But you have to do it carefully. You cannot remove that, or you cannot run bulldozers if people are there, already there. You will not be liable for trespass if you enter that land because that is authorized by the law. But you will be liable if you harm somebody while doing that. If that person has not been notified that such and such thing is happening. If that person on purpose enters the land, even when you have told them and a notice has been given for the removal, then if they suffer a harm, you might not be liable. Correct? Now, absolute and conditional authority. Now, what do you understand by absolute and conditional authority? Absolute authority is where even though nuisance or some other harm necessarily results, there will be no liability. So absolutely clear. Even if something wrong happens, you are completely clear. You will not be liable at all. When the authority given by the statute is conditional, it means that the act authorized can be done provided the same is possible without nuisance or other harm. Such a condition may be express or implied. So if the statute says that you cannot do it without, you do not have absolute authority, you have conditional, you have to try not to cause nuisance or harm. You cannot cause nuisance or harm. So under a statutory authority, what do you have to do? You have to follow the statute, nothing more of what the statute allows. And that is called statutory authority. So with this, we come to the end of the the law of general defenses. Now, after understanding these general defenses, the next topic which we will understand is capacity. Okay, capacity to sue. Who can sue for torts? So next we will discuss that.